it is safe to say that this is huge topic. Okay, I mean, I've done various different sessions on the Employment Rights Bill / Act over the last year, and in all reality, I could sit all day with you and go through the Employment Rights Act. So for the purposes of this session today, I have tried to pick out some of the headline points. This session by no means covers everything that the Employment Rights Act is bringing into force, but what I've tried to do is pick out the key areas that are going to be most impactful or most discussion points for employers going forward. Okay, so in terms of, it's the biggest overhaul to employment rights in the last 30 years, and that's not an exaggeration. It absolutely is. The Employment Rights Bill, when it was first tabled by the Labour government, was a 20-page manifesto that said we are committed to making fair pay for fair work. Okay. What has happened over time as this bill and act has moved through Parliament is it is grown arms and legs. And what we're actually looking at is over 28 law reforms. The legislation itself, by the time we got to the end of it at the end of last year, was rather than the 20-page manifesto, we'd accumulated 330 pages worth of new legislation that is coming our way. And on top of that, a lot of the changes are actually going to be so they're still going to be subject to secondary legislation. Okay, so it's not an exaggeration that this is the biggest overhaul to Employment Rights Act, and it will absolutely impact you as employers and your workers going forward. You know, the focus of the Labour government at the time that they put forward this manifesto, put forward this bill, was very much on, you know, working class, lower income families. So you will see as we go through this, a lot of the changes do relate to the likes of 0 hours, new SSP rights, new day one rights that they are planning to bring into force. But it's very hard to ignore, and it's impossible to ignore the potential cost to businesses of these changes. You know, Labour did an impact assessment, and they considered that it wasn't going to have a hugely detrimental impact on businesses. But I think it's impossible to ignore that it is clearly going to have an impact financially and operationally on businesses, and particularly the leisure and tourism sector going forward, a sector that, you know, is already struggling. On top of that, we then have the impact on the employment tribunal system. So from my point of view, we effectively have a whole host of new rights come in for workers that effectively give them extra protection, give them, you know, ways to bring claims, etc. But in reality, the context and the backdrop to that is we have an employment tribunal system which has been underfunded for a number of years and effectively is completely backlogged. So claims have already been on a rise over the last 5 years. We've seen a steady increase in the claims that are coming through the Employment Tribunal, and the government has, as part of their assessment, already said that as a result of these changes, they do expect maybe, say, a 15% increase on Employment Tribunal claims. So there is going to be an increase in claims inevitably, and the reason I'm giving you this context is because it is important, because whilst these new sections that come into force give workers protection and give them rights, the reality is it's very difficult for them to enforce those rights, or it's a very long, costly process to do so at the moment, because we have tribunals that are extremely backlogged. I'll pick up on that a little bit later as we go through talking about some of the changes that are going to come. So as I say, very quickly, background, this has been going on for some time. This has been my last, 18 months to a year of my life following this employment bill going through the Houses. It's been fascinating in the sense of what has happened is, I mean, it was first published, first reading was back in October of 2024. And actually in the summer of last year, July 2025, the government released a timetable of how they were going to implement this. And that was very much of the expectation that the bill would come into force, say, for example, autumn time. What actually happened in reality is it didn't receive royal assent until just before Christmas. So the 18th of December is when it became the actual act. Okay. And the reason for that was actually there was a huge amount of pushback from the House of Lords as it was going through its process. And I will go through the different changes that have been made, but the House of Lords were massively pushing back on the government on some of the changes that they were putting in place. So it has been watered down compared to what the first manifesto from the Labour government set out. Okay, so the biggie, the headline point, unfair dismissal. So this was very much Labour's kind of headline point. We are going to bring in day one rights in relation to unfair dismissal. Now, for anyone who doesn't know, at the moment, the current position is that an employee must have 2 years continuous service to bring a claim for unfair dismissal. If they don't have 2 years service, then it's much simpler process in order to kind of terminate their employment. Government wanted to bring in a 1 day, so it was going to be there from day one. This is what held up the timetable. This is what held it up getting receiving royal assent, because the House of Lords were adamant they were not going to agree, or they didn't agree with the fact of it being a day one right. So at the 11th hour, literally in December, just before it received royal assent, the government conceded. And effectively what we will now have in place is we will have a 6-month qualifying period. Okay, so it will drop from the 2 years, but it won't go to a day one right, it will be a 6-month right. So any employees who have 6 months service will now be able to bring an unfair dismissal claim if they have been dismissed. Okay, so from the business's point of view, you will have to follow a fair process and identify the fair reasons for those people who have over 6 months service rather than the 2 years. So it obviously gives us less time to play with and assess someone's suitability and that sort of thing. In terms of, it's important to point out, automatic unfair dismissal, those cases remain unaffected. Those are a day one right anyway. So stuff like health and safety legislation, dismissals for raising health and safety concerns, whistleblowing concerns, that sort of thing. This is going to come into force from the 1st of January 2027. So this, you've got a bit of time, but that's when it's going to come into force. And interestingly, one of the things that came out of kind of the 11th hour negotiations was the abolished the unfair dismissal compensation cap. So at the moment, unfair dismissal claims, the compensation is capped. Okay, so any compensatory award is capped at a year's salary gross for that individual, or that there is an upper cap as well, which is about £118,000. Okay, now the vast majority of employees are not going to hit that cap, so you're looking at kind of the 1 year instead. But actually, this massively opens the door in terms of claims going forward, that they are going to be uncapped in the unfair dismissal sphere. So if you are dealing with senior individuals, senior exits within your organisation where there is the potential of the cap, then going forward from January 2027, that's massively going to expose you financially in relation to those claims. So as I say, definitely exposure in relation to more claims going forward, and greater financial exposure in relation to that cap. So what can you do now? Practically, what can we be doing? How can we prepare for this? Okay, number one, recruitment processes are going to be key. Okay, actually, the best place to start is your recruitment process. If you can get the right people in the right roles, then this can hopefully avoid some of these issues going forward. But as I say, we do now have this 6-month period that we didn't think we were going to have to play around with. So secondly, your probationary periods. It's really important that we put these in place and effectively manage them. Some of you may have probationary periods already in your contracts of employment. If you haven't, you should be introducing probationary periods into your contract. But that's step number one. Step number two is actually making sure that you effectively use those probationary periods. There is no point having it in a policy, in a glossy folder somewhere, if actually your managers never look at the probationary period and it's never reviewed and there's no formal process for that active review. So my tip now would be to go away, look at your probation periods and make sure they are tight and that actually you have consistency across your business of how they are being dealt with and a formal process of how to deal with them. That will hopefully flush out any issues in that 6-month period that you have. Again, hopefully avoiding the need for kind of tipping over that 6 months and then suddenly realize someone isn't suitable for the job. Okay, another biggie and one that inevitably will impact a lot of people on this call, 0 hours and low hours. Okay, 0 hours contract have had a bad reputation for a while now. I actually personally am I'm a fan of them. I think they can work really well. I think they can work well for businesses. I think they can work well for the individual. The current legal position is you can have 0 hours contracts providing there isn't kind of an exclusivity clause in there. So anyone who's on a 0 hours contract is allowed to work for other employers at the same time. As I say, as part of the government's manifesto, 0 hours was a big one that they were, in their own words, wanting to crack down on, that they weren't being used unfairly. So the legislation that is coming into force in relation to 0 hours is complex, it's messy, and it's detailed. Okay, there is a whole host of different changes coming into place, and a lot of that is still going to be subject to secondary legislation. Okay, so I'll quickly run through what are the main changes that are coming. Okay, so the first one is that if someone is working regular hours, so they're on a 0 hours contract or a low hours contract, but they are working regular hours over a reference period, then at the end of that reference period, we as the employer will have a duty to offer that individual guaranteed hours going forward. Okay. There was a lot of debate about this at the parliamentary stage. The House of Lords were massively pushing to take away the duty and instead have it that the employee has to request the hours. That hasn't been successful. Okay, so the law that will come into effect is that the duty is on us, I say us as in the employer, to offer those guaranteed hours at the end of the reference period. The employee doesn't have to accept those hours, they can reject it, but we have to offer it. And actually, if we get to the end of the next reference period and the person has previously rejected it, we would still have to re-offer it again. Okay, so that's the position in relation to offering guaranteed hours. There's going to be certain information rights that we need to provide to workers. So the fact of these changes that are coming into law are going to have to be given in written notice to the individual, similar to sort of your Section 1 notice, that sort of thing. You're going to have a duty to provide reasonable notice for shifts, and you have to give reasonable notice for cancellation of shifts as well. And there is the possibility for compensation if we effectively do not give reasonable notice for cancelling or moving shifts. This is going to cover agency workers as well. So if you hire agency workers as the end hirer, so as the end employer, you will be also liable to offer the guaranteed hours to agency workers if they hit the requirements within that reference period. The legislation also brings about an automatic unfair dismissal. effectively raising this point. So if an individual raises this point or tries to rely on this protection and we dismiss them as a result, that will be an automatic unfair dismissal. So you probably think, because I said a lot of words there, which are ultimately still subject to secondary legislation. Okay, so here are some of the definitions that we still don't know what the answer is going to be. Okay, so number one, low hours. So I talk about 0 hours, but it also references low hours. There is going to be a consultation and there is going to be a determination and guidance as to what low hours will be. Okay, where that's going to land, it's really difficult to say. You know, that there's going to have to be some sort of arbitrary figure on it, but I would think it's got to be in the low sense in terms of kind of say 4 hours a week or something along those lines. But we'll have to wait and see what that comes from. Reference period. So what is going to be the reference period? Again, we don't know that yet, and that's going to be subject to secondary legislation. But as part of the debates, part of the process going through Parliament, there was indications and commentary around that potentially looking like a 12-week reference period, which would make sense. That kind of aligns with other legislation, you know, in relation to reference periods. We don't know how long, what the prescribed offer is going to be. Does it have to be in writing? Can we, you know, how's that going to take effect? And how long does it have to remain open for? Once we offer it to the employee, how long do they have to effectively accept it and or reject that offer? Again, we don't know, but there has been commentary throughout the debates which suggests maybe a week. That the offer would remain open for say a week, and expectation sections that won't apply to this. Okay, and this is going to be really relevant to a lot of people on this call, because this was a big point for the House of Lords that were pushing that actually we need to have you know, areas of work that fall out of this, and seasonal workers is a biggie. Obviously, seasonal workers, they work very often on 0 hours contracts. It fluctuates in demand. We have to have that flexibility, you know, and actually it works for the individual as well. So we're hoping that the consultation will bring out a description that catches seasonal workers as an expectation, you know, one that can be pulled out of the 0 hours. But at the moment, we don't know that, and we're waiting for the consultation to be formally launched. Okay, so what can you be doing now? Okay, in terms of time frame, this will take effect in 2027. Okay, so the rules will come into force in 2027. The government have said there is going to be a consultation launched early this year. So they announced it at the end of last year, but it hasn't formally launched yet. Okay, so we're still waiting for that to arrive, but that will help shape what this legislation looks like in reality, and help shape some of those you know, points that I mentioned before in terms of definitions. Obviously, it massively impacts the leisure and tourism sector and a whole host of their workers. So what can you do now? I would be saying carry out your workforce audits now. You know, you have the time. This isn't going to take into effect till 2027. So be prepared, do an audit now and see how much this is likely, you know, how is this likely to impact you, impact the business and impact your workers. Identify those fluctuations, those seasonal fluctuations that you have, and actually consider, is there alternatives that we could put in place here? So rather than using 0 hours contracts across the board, would it be better for us as a business to actually say, for example, use fixed term contracts for short-term periods or annualized hours or something of that respect? It will be different for different organizations, but do that assessment now. Start thinking about this now, because whilst I say it's 2027, we all know that will creep up on us as well. In terms of one other point I think you should probably look at now is your system for kind of managing the shifts, how you do that. Do you have a formal system, or is it very much a WhatsApp group where people just kind of, shifts are thrown out there and we see what happens? Because with the changes to, reasonable notice and late cancellation, that sort of thing, you probably want to be moving towards a more formal system or something definitely more centralized that you have control of, to monitor the shifts and changes and cancellations and stuff like that. Okay, so that was 0 hours. Discrimination and harassment. Okay, so you should all be aware of in October 2024, there was legislation passed at that point that provided that employers needed to take reasonable steps. There was a duty on employers to take reasonable steps to prevent sexual harassment. Okay, so that came in 2024. And businesses have been implementing that since and kind of putting in place measures to help prevent sexual harassment in their workplace. Again, whilst that was going through the statute books, there was this push for the definition to say all reasonable steps, and that got pulled at the last minute in 2024. What the government have done now is they've effectively put that back into the statute books. So the new duty going forward will be to take all reasonable steps to prevent sexual harassment, and there is also going to be a duty to take all reasonable steps to prevent third-party harassment. This is huge. Okay, so we used to, way back when, there used to be a law on third-party harassment, and it was effectively a little bit of a two strikes and you're out. Okay, so if a customer was harassing your member of staff, if you knew about it effectively on 2 occasions, you did nothing about it, then that individual, the employee, potentially would have a claim against you. Okay, as the employer for failing to prevent that. That was abolished some time ago, and we've had a period of time where there hasn't been any legislation in relation to third-party harassment up till this point. Okay, so this has now come back on the statute books, and it is now going to be something that you will have to deal with. Okay, the changes that are coming into effect, they are going to come into effect in October 2026. Very unhelpfully, in the government's timetable, it says that secondary legislation that will explain what all reasonable steps is will come in 2027. I hope you're with me. That doesn't make sense. Okay, we obviously have a complete disconnect there. Now, hopefully, we will get guidance before that, but at the moment, that is what the timetable says. Okay, it's a really onerous duty because to take all reasonable steps to prevent sexual harassment or any other harassment from a third party is obviously huge. Your customer facing roles, your workers who are client facing, customer facing on the bar, or, front of house, constantly interacting with customers. What steps can we take? What reasonable steps can we take to prevent that? Okay. Now, at the moment, there is guidance in relation to the reasonable steps for sexual harassment. And the guidance essentially says, as an employer, we should be doing risk assessments to assess where the harassment could be, where are high risk areas where harassment could happen. We should be putting steps in place to prevent that in terms of minimizing those risks. What steps can we take to minimize those risks? We should be delivering training to all our staff on harassment in the workplace and what is acceptable, what isn't acceptable. We should be dealing with complaints promptly and effectively, and we should be monitoring complaints going forward as well, and identify any key points that are coming up. But I think, again, ultimately, and I appreciate you will see a theme with this this seminar, which is effectively a lot of this is undecided. Whilst we have the legislation, there still isn't really effective guidance from the government or from secondary legislation of exactly what this means. Okay, but in terms of what you can be doing, what I consider to be reasonable steps that you could be taking now to prepare for these changes is look at an action plan. Okay, as I said before, a risk assessment. Where are your high levels of risk of harassment within your workforce, within your sites, and what can we do to minimize those risks? Secondly, what are we doing with our commercial terms with third parties, so suppliers, etc., contractors, but also our customers? What are our terms with our customers? We engage with commercial terms with our customers at all times. Does that include, and do we have wording, literature, etc., commentary about our expectations of our customers and the fact that we don't tolerate harassment of our staff, and make that very clear in a proactive approach? Again, public signage for some of you, it's all well and good having policies sat on a shelf somewhere in an office, but actually we need this to be out there publicly. We need this to be front of house. We need this to be on our bars, etc. So again, public signage is something you might want to be looking at. If you are getting complaints, if things are raised by staff, even if it's on an informal basis, you should be dealing with that and dealing with it promptly and transparently and fairly. Okay, you don't want to be ignoring complaints or kind of brushing them under the carpet in the sense of, oh, it's so, and Jill said it was fine. She just wanted to tell me, but she didn't want anything done about it. You can only take that approach for so long. You have to actively be seen to dealing with these harassment issues. And ultimately, I've touched on policies. I'm very much my approach with policies. I think policies are needed and are sometimes necessary in terms of kind of internal governance, but actually your policy is only as good as your implementation of that policy. You can have the all singing, all dancing, document and spend all your time drafting these policies up. But actually, if you do not implement them, if you do not roll them out to staff, if you do not provide the training going forward on this and the cultural, awareness that comes with these policies, they're not really worth the paper they're written on. In a tribunal claim, inevitably tribunals are savvy to this and they will look behind the reason. We can present policies, but if ultimately they're not being, no one's read them, no one's looked at them, they've not been rolled out, they won't be viewed very favorably by the tribunal. Okay, so limitation periods, this has been one that's been on the books for a little while, but effectively at the moment, the vast majority of employment claims, if an employee wants to bring a claim or a worker wants to bring a claim, they need to bring the claim within 3 months of the date of, or within 3 months of the date of the whatever it's happened, dismissal, discrimination, etc. That is going to be increased to 6 months. And that will be effective from October of this year. Okay, so limitation periods are going to go up to 6 months. On top of that, for context, ACAS early conciliation, that is a process that an employee has to go through before they bring a claim. And the ACAS early conciliation process stops the clock. Okay, so they could contact ACAS early conciliation on their last day of the 3 months, and then it would stop the clock, and then they'd have the whole ACAS process, and then they could bring the claim after that and still be in time. In December of last year, that extended from 6 weeks to 12 weeks. So ultimately, we are in a position where in the next year or so, employees are effectively going to have as long as sort of 10 months to bring a claim against against a business, against an employer. That's a big change to how we used to deal with it. Tribunals were very much set up on the basis of kind of quick and easy access to justice for both parties. And that's just not happening. The backlogs don't help. So in reality, I think we will end up in a situation where you've got employees maybe taking 10 months to bring a claim, and then you're then in a backlogged tribunal system, unfortunately, which at the moment, my claims that I'm dealing with, you're talking 18 months to 2 years for it to get to a final hearing. You all know in your workforces the turnover of staff in that period of time and the likelihood that you are going to have the same witnesses that occurred, were involved in an event that happened 3 years ago, still available to give witness evidence, can be really damaging and really difficult for an employer to deal with. Again, I don't have a particular answer to this one in terms of approach. It's more to give you the context of why actually it's important we deal with things properly internally to help minimize the risk of these claims, because once you are in a claims process, it's a lengthy, costly process. Okay, so there's quite a few changes that are coming into force in relation to kind of family and pregnancy. Pregnancy discrimination, again, there has been a lot of campaigning, a lot of lobbying of the government in respect of protection for pregnant women, women on maternity leave. I mean, in 2024, the stats came out, it was effectively 74,000 women a year are pushed out of their jobs or dismissed or made redundant as a result of taking maternity leave or being pregnant. So the government have kind of responded to that, and this is effectively their response. So they are going to strengthen the protection for pregnant women. So at the moment, some of you may be aware, but if a woman is pregnant or on maternity leave, on their return, they have additional protection in relation to redundancy. So if there is a redundancy situation, that individual has effectively an enhanced right to any suitable alternative employment. Okay. They are looking, the suggestion is, and what legislation has been set out to allow, is that additional protection that we have now for redundancy will be extended to other reasons, or may be extended to other reasons for dismissal. They have not committed to how this is going to look in terms of whether it's going to be all different reasons for dismissal, i.e. Conduct, capability, etc. I can't, I struggle to see how that's going to play out in a conduct aspect. But what's going to happen going forward is there's been a consultation started already on this that actually ended on the 15th of January. So we are now waiting for the feedback from that, the government's response to that, and then we will see what that is coming forward. That's going to be a 2027 change that's coming into place. A couple of other changes, paternity and parental leave. So these will become day one rights as of April 2026. That's not necessarily right to paid leave, but it is the day one right to the leave. Then on top of that, we have statutory bereavement leave looking like it's going to come into force as well, 2027, and there's been a consultation on that, so we're waiting for that to come out as well. Another change that I'm sure you may be aware of already, statutory sick pay will also become a day one right. Okay, so rather than the waiting period of the 3 days, employees will get statutory sick pay from the day that they take off, providing they hit the requirements of the legislation. It's going to remove the lower earnings limit, so employees will either get 80% of their average earning or the SSP weekly flat rate, whichever is lower. The weekly flat rate as of April 2026, that's going to be £123. Yeah, £123.25 as of April 2026. Okay. Obviously, from your point of view, there's only so much we can do to kind of minimize the impact of this. I think what I would say is make sure now your reporting processes are clear in relation to sickness reporting, so that there is, again, you've got clear audit trails for payroll. We've got clear records, employee data records as to sickness, absence, and the cost associated with that. So if you're not sure, look at your sickness reporting procedures now, make sure they're nice and tight, and make sure they're rolled out to all staff and managers ahead of April change. Okay, tips. So again, I suspect you're all aware of, in October 2024, there was a change to the tipping legislation in relation to making sure that tips were dealt with fairly and passed on to staff, etc. So the new changes that are coming in the Employment Rights Act essentially just strengthen that. There is already a code of practice in relation to tips and how you manage tips for your staff, and effectively the Employment Rights Act now just gives statutory provision to that. So what it means is that when you're creating a policy on tips, which is the current position, you should have a policy on your tips. Then what you should do is you must consult with workers in relation to that policy before you introduce it. Okay, if you have a trade union, then that needs to be done via the trade union, or if you have worker representatives, it will be done via them. If you don't have either of them, it must be done directly with the workers. Okay, on top of that, there is going to be a statutory 3-year review cycle, so you will be required to review this policy every 3 years. Okay. Okay, so touching very briefly on trade unions, I touched on it there in relation to tips. Now, as I said at the beginning, you can see the wealth of changes that are coming our way. There's a huge amount. The changes that are coming in relation to trade unions are huge and they are vast, and as I say, I couldn't possibly cover them in this session alone. Okay, so ultimately, number one, if you have a trade union already, so if you are union recognised, then you do need to look at these changes. You will need to become familiar with them, and actually some of those changes are taking effect immediately. So if you are already union recognised, definitely look at this. If you are not union recognised, my advice is do not ignore this, because actually what is going to happen as a result of these changes, the changes that have been brought about in relation to trade unions, is to ultimately make it easier for trade unions to be recognised within workforces. It's going to make it easier for trade unions to have access to your workforce. Okay, so traditionally areas that haven't necessarily been unionized in the past are now going to be more likely to be on the union's agenda, on their agenda to pick up on. Okay, because there is going to be an increased right of access to the workplace, so unions are going to be able to access your workforce much more easily going forward. And there is going to be a simplified process for ballots, which means it's going to be a simplified process for recognition as well. Okay, so it's going to be easier for unions to be there. On top of that, there's then sort of reduced periods for industrial action, and e-ballots are going to take place. So at the moment, everything has to be done via paper. So this is bringing effectively union membership into the 21st century, so it can be done electronically. But as I say, back to my initial point, if you're recognised, look at this now and get advice on how it impacts you. If you're not recognised, don't ignore it. It may be something that is relevant to you, and you may need to seek advice as you go through this process. Okay, fire and rehire. You'll have likely heard about fire and rehire in the sense of the P&O case, where effectively they dismiss their entire workforce and replace them with agency workers. So that's how commonly it's been referred to fire and rehire. But actually, when I'm talking about fire and rehire today, what I am talking about is if you are changing terms and conditions of an employee or worker's contract, then effectively you usually have kind of three ways to go about it. Okay, so say you want to change holidays or pay rates or something like that, overtime rates. There are three ways you can go about it. Number one is to get agreement from the staff. So you put it out for consultation and you get their individual agreement to that. Number one, happy days. That's the situation we want to be in. But what happens if you don't get the staff's agreement? And as a business, you have to make these, we have to make these changes going forward. Then effectively there's two options available to you. There's either you can unilaterally impose it, which means you can just impose it and then ultimately see what the employees do. The employees have the right to maybe resign, claim constructive dismissal, etc. Or you can go through what is a process is called dismissal and re-engagement. Okay, so that is where you would go through the process where you do a full consultation, you try to get their agreement to the terms and conditions. If they are still refusing unreasonably to accept the terms and conditions, then you effectively would dismiss them on the grounds of some other substantial reason, and then you would effectively re-offer them the terms and conditions immediately after on the new terms and conditions. Okay, so this has been a practice that's been used for a long time to allow businesses to make changes and to minimise their risk in relation to compensation payments, unfair dismissal, that type of thing. The changes that are going to come into effect will massively impact them. And actually, initially, it was much wider. So you'll be pleased to know it has been limited in its scope. Okay, so what is going to happen is if someone is dismissed because they haven't accepted terms and conditions, then effectively that is now going to be an automatic unfair dismissal. Okay, so it massively limits the employer's ability to change terms and conditions going forward. Now, as this was going through Parliament, initially the first draft, or even the second and third draft, was that this applied to all terms and conditions, which was madness in the sense of it wouldn't allow any changes going forward. Thankfully, what's happened as it's gone through Parliament is it has been restricted, okay? And it has been restricted to contractual matters called restricted variations, and they would have to concern their pay, their hours, or say, for example, holiday pay or right to holiday. Okay, so if you're looking to change those restricted variations, then you are not allowed to do it, and it will be an automatic unfair dismissal unless you can show financial difficulties. Okay, you would have to be able to do this, you would have to show that effectively the ability to continue the business is at risk or will be at risk in the immediate future. It is unlikely to be enough, and there has been discussions about this as it goes through, it's unlikely to be enough to say that, well, actually, we need to make this change to avoid being in that situation. Okay, so we need to make this change to save money, but it's not the case that we're going to close immediately. You know, we can't afford to continue. So that's a really limited scope. It's a really narrow definition, because in reality, an employer, if they're going to be making changes to terms and conditions, wants to be proactive in that approach to help save costs and save the business going forward, not doing it as a last ditch attempt, by which point the likelihood is the business is no longer viable. Okay, so it's going to be really, really difficult going forward, and we are expecting I'm expecting there to be case law come out of this, and I'm expecting there to be legal challenge in relation to some of these cases, and what the government means when it says about financial difficulties, and how immediate does that risk have to be. Okay, so this is going to take effect in October of this year. Again, this is subject to consultation. So that is one of the 26 consultations that will be coming our way at the start of this year. So we've got lots still to come on this. But practically, what can you do now? And I would be looking at your contract terms now, particularly looking out for, do you have any inconsistencies? Do you have any historic things that ultimately, might want to be changed at some point? And if you really need to make changes, you want to be doing them sooner rather than later. That said, any changes will still be subject to the current rules, which is ultimately they would have to be reasonable and fair. Okay, so again, if you are thinking of doing that, you should take some advice in respect of that. General advice on changing terms and conditions generally, it's always preferable to link those changes to pay reviews, to promotions, etc. You are much more likely to get agreement, which is option number one, happy days, from the individual if you can link it to some sort of reward, benefit, something of that nature. Okay, collective consultation. So this relates to redundancies. So where you are making 20 or more redundancies in one establishment in a period of 90 days, then you have to go through what's called collective consultation, and there is set time frame for doing that, 30 days or 45 days depending on numbers, to collectively consult, and that would either be with the union if you're recognised, or with employee representatives if you don't have a union. Okay. What is going to happen going forward is there's a slightly different definition of this. So at the moment, as I say, it's 20 or more employees in one establishment. If you have different sites, so if you are an employer who has, say, for example, hotels at different sites, then the current test is one establishment would be one site. Okay, so for you to hit this threshold, you'd have to be making 20 redundancies or more at that one site. Okay, so that gives us a degree of flexibility across various different sites and the overall numbers. But what they are adding into this definition now going forward is that they are going to introduce an overall threshold number as well. So say, for example, you were doing 20 or more redundancies, but they are spread across different sites, then at the moment you wouldn't hit the definition. However, going forward, if you hit the new threshold number, then you would still hit collective consultation. So this is likely to catch more redundancy processes. It is likely that there is going to be more collective consultation. As my favourite saying throughout this webinar is, this is subject to secondary legislation, but we are still waiting to hear what the threshold number is going to be. There has been commentary as to whether it's going to be an overall number, for example, say 100, or whether it's going to be a percentage. So whether it will be based on a percentage of your overall head count. So that's one to watch and one to look out for going forward. On top of that, what they are going to do is, if you get this wrong, so if you don't carry out collective consultation, or you trip up and manage the process wrong, then at the moment you can be subject to a protective award of up to 90 days per employee. That is going to go up to 180 days per employee as of April of this year. So very costly. They were already costly at the 90 days. They've doubled that. So they're really hammering down and making sure that employers go through this process and do it properly and involve the employees going forward in collective redundancies. The Fair Work Agency. Okay, so this was one of the ones that in the Employment Rights Bill, it was kind of at the beginning, I would say it was overlooked a little bit, and people kind of thought, oh, Fair Work Agency, that's interesting. But they were kind of more focused on the laws that are coming into effect. But the Fair Work Agency, what is going to happen with the new Employment Rights Act is this is going to be a new government body in place from April 2026. Okay, and what it is going to do is it is going to amalgamate a lot of different government departments that are ultimately responsible for looking at underpayments and stuff like that. So we're going to have one, or the theory is we're going to have one centralized agency that is going to have responsibility for enforcing employment rights. Okay, and that is going to cover SSP, national minimum wage payments, holiday pay, unlawful deduction to wages, and ET claims awards, amongst a few other things. But those are the main ones from an employment aspect. Now, holiday pay, for me, looking at that list there, that's a scary inclusion there. And the reason being is what I tend to see is that holiday pay is the area where employers trip up the most. Okay, and it's not through any fault, in the sense of holiday pay has been one of the most complex areas of employment law over the last 10-15 years, and it has developed significantly through case law, through European involvement, etc., where ultimately we got to a position of probably clarity now, but what has quite often happen is employers at one time or another has probably been paying in holiday pay incorrectly. As I say, not through any fault of their own, but simply because it's a really complicated system, particularly when you have employees working on, say, 0 hours, irregular hours, reference periods, all that sort of stuff. Okay, so the Fair Work Agency will now take responsibility for looking at holiday pay, amongst other things. They will have the power to bring employment tribunals on behalf of workers. Again, this is a huge development and massively changes the landscape of litigation in the employment tribunals. At the moment, as I say, let's take holiday pay for an example. As I say, employers have maybe been paying it incorrectly. That is at some point flagged on their system and they go, oh no, we've been paying holiday pay incorrectly. What do we do about it going forward? Okay. And quite often what will happen is we will rectify it going forward, but inevitably by rectifying it, there is, it's almost flags to the employees. Oh, hang on, I'm now getting more holiday pay. So what was the situation before? And there's various ways of dealing with that. Some employers will go in very proactively, and we will ultimately offer back pay and we'll do settlements with those particular individuals. Another approach from a commercial point of view is actually to take it very much case by case. Okay, so you say, okay, well, we're going to rectify this going forward, and if and when employees come to us, we will effectively, we'll deal with them on a case by case basis, and we'll ensure we kind of settle them and pay them appropriately if and when raised. So suddenly, now you've got the Fair Work Agency potentially bringing those claims on behalf of workers. So suddenly your strategy, your commercial strategy that we just outlined in option 2 there, suddenly feels not very viable anymore if actually the threat is coming from a third party in relation to claim. So that is a huge development that will need to be watched and see what happens there. They can provide legal assistance to those individuals, and they can recover the costs of enforcing the proceedings as well if needed. On top of that, they are going to have the power to issue notices, so notices of underpayment. So if on a very simple assessment, there has been an underpayment, say, for example, of SSP or national minimum wage, then effectively they have the power to issue an underpayment, and you as the employer would have to repay, but that can also be at a higher percentage. So they can issue a notice of up to 200% of the sums due. Okay, and that ranges from anywhere from £100 up to £20,000 per employee. Okay, so they already have this power in relation, for example, to national minimum wage, etc., is kind of dealt with by HMRC. But what this is going to do is it's going to bring it into one body and one responsibility for enforcing. Late last year, they appointed a new CEO for this agency. So the wheels are in motion. This agency is absolutely coming to take effect. And I think, again, speaking frankly, I think given they are ploughing money into having this agency, they will want to be seen to be effective and want to be seen to be doing things. So I do think we are going to see action coming out of the Fair Work Agency. As I say, how much action we'll have to wait and see. Okay, so just again, to reiterate what I said at the beginning of this webinar, there is a whole host of changes, you know, and I appreciate I've kind of rattled through some of them, but the reason being is I didn't want to, you know, miss out big sections, so I wanted to put them on your agenda, so at least you can go away and you've got your red flags and you can come up with a bit of an action plan of how some of these changes are going to impact you and your business going forward. So stage number 1, definitely go away, review your current practices in light of what I've told you, and look at, okay, well, what are we most going to be impacted for, and how can we prepare for those changes going forward? Okay, so for example, we've talked about 0 hours, low hours. If you are an employer who employs workers on 0 hours, absolutely be doing your audit now, okay, of the impact on your business, and whether it's going to be the right thing to keep those individuals on 0 hours, or whether we could move them to some sort of other contractual arrangement. Okay, for some businesses it will make sense, it will still make sense to use 0 hours regardless of the admin burden that comes with it. Okay, but for other business, you might be able to identify those fluctuations, and therefore there might be other ways, annualized hours, fixed hours, etc., in which you can offer different types of contracts to these individuals to take away some of the admin burden that comes with the new 0 hours regime. Okay, get your procedures in place now. So as I say, your sickness absence, particularly in relation to SSP coming into force, get that signed, get that tight, get that sent out. But also in relation to the changes that are coming with unfair dismissal, I think it's important that now you do look at your probationary process, your probationary review meetings, how that is dealt with, what is the process in relation to that, and generally your disciplinary procedures and your capability procedures as well, to make sure that they are up to date and watertight for the changes that are going to be coming. Third-party sexual harassment and general harassment. I mean, ultimately, as I say, these changes aren't coming into force right this second, but we already have the changes that came into force in 2024. You should already be taking steps to prevent sexual harassment in the workforce, i.e., employees sexually harassing other employees. Okay, so if you've already done that, great. Continue with the work that you're doing, continuing with your monitoring, continuing with your training and implementation of that. If you haven't done that, take action now. You absolutely should be taking action now. Failure to do so, even in the current law, is up to 25% increase on any tribunal compensation that is awarded. So it's absolutely imperative that you do take steps now. Obviously, identify your problem areas for you and for your business, and seek advice kind of as and when needed. Again, I kind of you know, as we've been going through this process, particularly at kind of the start of last year, there was a lot of conversations about the employment rights bill, but at that stage, my message to employers was very much, you know, you don't need to panic. You know, actually, this is still going through Parliament. There's a lot still to be determined. So actually, you know, don't make any knee-jerk reactions based on what we knew. That was kind of back at the start of last year. We do have more information now, and while some of it is still subject to secondary legislation, I think you have enough, really, as I say, to be planning how you as a business are going to approach these changes. So do seek advice if you need to. We can obviously help you in terms of your policies, your procedures, and making sure your contracts are right. But also, if you need training, so as I say, your policies are only as good as the implementation of it. So if you do need training for your leaders, for your managers, again, that's something that we do on a regular basis with clients. And obviously, ultimately, if, you know, actually, as a result of your audit, as a result of your review, there is a restructure needed and that there does need to be changes made, then obviously we can help with the workforce planning going forward as well. Okay, so as I say, I'm very conscious there was a lot of information there. So again, more than happy to take any questions that you've got or on, you know, anything I've raised, or equally anything that I haven't raised. I'll answer as well as I can. No, I think I've stunned you all into silence. Well, if that's the case, I'll sign off then. But I mean, ultimately, you've obviously booked through Cumbria Tourism. I'll put, there you go, my details are on there as well. If anything does crop up afterwards, and you're not sure and you just want to check a point, please do just drop me an email. That's absolutely fine. I'm more than happy to pick up with you. So please do reach out if you need anything. And as I say, I hope it's been helpful. I hope it's not been too scary. But as I say, there are changes coming. So planning is key. Definitely, I think 2026 is to plan for these changes. Thank you, everyone. Thank you. Goodbye.